Yes, Miss Lee.
My ladies, my lord, I was going to give you the citation for the GE Eritrea case.
Oh, yes, thank you.
It's 2014 EWCA Civ 1490.
Thank you very much.
In terms of the factual matters that are relevant to the fact that to our case, that this is an academic case, I don't know whether or not your ladies and my lord have got the agreed statement of facts that is in the supplementary bundle tab 1 relating to the age assessment by Southampton. That may not have been drawn to your attention because it came later after the skeleton arguments were put in. And you may not have picked this up as well, but Southampton was a defendant in these proceedings when they were first started.
Right.
And they fell away as a defendant after the commission decision was made by Richard Homer QC, sitting as a executive judge, on the basis that the quarrel on the age dispute primarily is a quarrel between the appellant and the respondent. But they were, prior to that, obviously, provided a copy of the age assessment because they were part of the defendant.
Yeah.
And they also had the defence from the appellant as well. And subsequent to the judgment, those instructing me provided them a copy of the judgment in this case in the lower court. So in terms of the issues that were in dispute, the summary of the evidence that was in dispute between the parties, they were provided a full copy of it.
Right.
From the respondent's perspective, because his age has been accepted by Southampton, because he is being looked after by them now as a care leaver because he's over 18 on his own case, he has no personal interest in the outcome of this appeal. And as I submitted before lunch, the appellant is also not being asked to do anything for him or refrain from doing anything to him. So from a sort of starting point, this is an academic case in terms of issues between the parties.
Yes.
But the court will be very familiar with the test in academic cases, and that's the case of ex parte asylum. Could I ask your ladyship and lordship to turn up Zoo Life, which sets out the asylum test, and that's in the Authorities Bundle, tab 2, page 29, paragraph 32.
Do you know what I think I've done? I think I've left my authorities bundle in my room. Could you maybe just ring my clerk, please? Thank you. I'm so sorry. Do carry on. I've just been an idiot, I think.
So
which paragraph?
It's paragraph 32, my lady. You'll see there's a quotation. It's bolded, ex parte asylum, and it's Lord Flynn's judgment there for the court. And the key points there is that, firstly, in terms of academic claims, it's a discretion to hear a dispute, but that discretion must be exercised with caution.
Yeah.
And appeals, which are academic, shouldn't be heard unless there's good reason in the public interest for doing so. And Lord Sen gives two examples where that may be the case, not is the case. Firstly, where there's a discrete point of statutory construction, which doesn't involve detailed consideration of the facts, that's not this case. Or where a large number of similar cases exist or are anticipated so that the issue most likely will need to be resolved in the future. He then goes on, this is Mr. Justice Silver's decision in Zoo Life. He goes on to look at another House of Lords authority called Ex Parte Win, and I draw the court's attention to his quotation, which is that this House doesn't decide hypothetical questions because, and the reason because they don't, is that this would constitute no more than obiter dicta and wouldn't be a binding precedent. Mr. Justice Silver then looks at two other cases which essentially say the same thing, but if I could turn the page over to paragraph 36, he then gives his conclusion on a review of the authorities and states that, in my view, these statements show clearly that academic issues cannot and should not be determined by courts unless there are exceptional circumstances, such as where two conditions are satisfied in the type of application now before the court, that there are a large number of similar cases that exist or anticipated, and the decision is not going to be fact-sensitive on appeal.
I mean, there have been further decisions about this. There's a decision of Mr. Justice Lewis, as he then was, in a housing case, and there have been at least two decisions of this court.
And I was going to take you to those, because it's important to note, of course, as your ladyship has identified, that this is a first instance case. So Zoo Life is about whether you allow a judicial review to continue when the judicial review issues are academic.
Yeah.
And even in that context, it was exceptionality, and because the exceptionality has to be directly linked to the public interest. In our respectful submission, this applies even more so to academic appeals. And this court has looked at that particular issue, and firstly in the case of Hutchinson, and that's in your bundle at tab 7.
That's the case I always think of as Pop Dog, because that's the name of the other party.
Yes,
slightly easier to remember than
Hutchinson. It is a much more memorable term,
Yes.
and I usually use Pop Dog, but I was corrected once into using Hutchinson.
Well, I'm sorry, I would have done just the opposite.
Well, I'm glad. And I mean, the head note is a summary of the principle, but I would take you to the judgment itself. But in the head note itself, it says the mere fact that a projected appeal may raise a point or more than 1 point of significance does not mean on its own it should be allowed to proceed where there are no longer any real issues in the proceedings as between the parties. And again, it's about exceptional circumstances. It's worth just bearing in mind, in that case, it was a case about a breach of confidentiality and a breach of a risk of a breach of private information being published. And Mr. Hutchinson was trying to stop Pop Dog from publishing information about him that was confidential. He got an interim injunction, and then they settled their claim, but agreed to continue the interim injunction. And there was a question as to whether or not the interim injunction ceases to have effect, and a judge said it did, set aside the interim injunction, but granted interim relief whilst he appealed that decision. A newspaper comes along and says, well, I actually want to publish that information, and Mr. Hutchinson responded to that by applying for another interim injunction and was unsuccessful. So by the time his appeal in relation to the first decision was heard, his information had already been published. So factually, his information had already been published, although this court identified and recognized that there was a potential public point of interest because of the question of what a judge should do in considering the discharge of an interim injunction in a confidentiality case. So on that basis, this court, it was Lord Justice Newberg, it was Master of the Rolls, Lord Newberg, at paragraph 15 of the judgment, and that's page 137 of the authorities bundle, internal page 786. And it's 15, it says, though the cases and general principles seem to suggest that, save in exceptional circumstances, 3 requirements have to be satisfied before an appeal, which is academic as between the parties, may, and he says, and I mean may, be allowed to proceed. Firstly, the court is satisfied that the appeal would raise a point of some general importance. Secondly, the respondent to the appeal agrees to proceeding. And thirdly, the court is satisfied that the parties are fully able to ventilate the arguments. You'll see at paragraph 16, he accepts that there was some point of principle raised, but in the end, the case did fall down on that first hurdle, because at paragraph 18, he says, well, the point of principle that was an issue would now be of limited relevance because it's superseded by practice guidance that is issued. So that's paragraph 18. That's one reason. And over the page, the court will see that the second reason is although there is another case that is often relied upon, there's a question as to whether or not it was rightly decided. But the court decided, well, that actually probably doesn't have any practical effect on the ground. And secondly, at paragraph 20, would it have mattered in this appeal if it were to be considered? So those were the issues that led this court in Hutchinson or Popdog to decide, well, there may be a point of principle, but that itself is not a basis upon which we would go ahead and hear the appeal. Then there is the judgment in Rahoon and London Borough of Islington, which is the tab 9 of the authorities bundle. This may well be what your ladyship is thinking of, but it is essentially a case which...
No, it's not the one I'm thinking of.
But it's another case of this court, and you will see at paragraph 24, it's the conclusions of this court on why that appeal was academic and shouldn't be allowed to proceed. Firstly, although the court recognised that there was a point of importance in that case because it concerned the lawfulness of transparency of a policy on discretionary housing payments. And also recognised at paragraph 25, you'll see...
Sorry, whose policy was it? Was it the local
authority? It was
authorities?
the local authority of London Borough of Islington.
Yeah.
So Rahoon is the individual appellant complaining about the lawfulness of the transparency of policy.
No, I just wanted to check whether it was a government policy or a local authority policy.
It's a local authority.
Yeah, okay.
And although this court accepted that there was, something of an importance because obviously a policy, if it's not transparent, could affect more than just this individual. Yeah. It affect more people. However, there were two reasons why this case was deemed to be academic. Firstly, the transparency issue wasn't an issue in the High Court. So it wasn't argued in the High Court. It wasn't considered thoroughly in the High Court.
Sorry, are those reasons why the appeal was academic, or were they reasons why the court didn't exercise its discretion to hear an academic
appeal? So it's the latter.
Right, okay, because the two issues are separate, aren't they?
That's quite right, yes. So it's a latter issue. It wasn't pleaded as an issue, and you see that at the top of paragraph 26.
Yeah.
The consequence is that the respondent has never had the opportunity to fully investigate and consider this point. And then secondly, the court also considered, well, could this be looked at in another case, because we are obviously a bit concerned that there is this non-transparency. And at the bottom of that paragraph, it says, if the lack of publication does continue to raise an issue of wide and general application, it seems to me to be likely that there will be other cases that raise it where the facts can be properly investigated to determine the rights and obligations that are actually at stake. This is the appropriate way for this issue to be resolved. So it's
very much on the facts of that case, though.
It's very much, but all cases concerning should you grant allow the appeal to go ahead, because even though it's academic, has to turn on is there a general point?
Well, sorry, so again, it's important to distinguish between whether or not the appeal is academic, and I don't think you have to push very hard to persuade us, to speak for myself, that the appeal is academic. I think the issue more, perhaps, is whether or not the court's discretion should be exercised to hear the appeal.
That's quite right, and I do accept that. I'm simply going through the structure of the test.
All right.
So, I mean, the rest of my submissions is going to centre on the proposition that the judge made a fact-sensitive judgment, and I'm going to take you through the judgment to make good my point, and that nothing that he said, firstly, gave rise to a point of general importance, but secondly, a general point of importance that requires clarification. So it's not just if he says something that might be important, but is it something that's important that creates conflict or confusion that requires clarification, because that is what would be in the public interest to do.
Okay.
So, first, our general submission is it's fact sensitive because it doesn't lay down any point of general importance. But importantly, it's not a challenge to the way local authorities generally conduct age assessments, nor was it the appellant's evidence that how they assess the respondent. So the evidence before the court wasn't that this is how we just generally assess people in this situation, and if you had done this, if you decide against us, it would affect others. That's not how the case was put in the lower court, and this court's consideration is, did the court get it wrong? And we say no, because if we can start by taking up the judgment and take each paragraph carefully, it's the judgment and the conclusion start at paragraph 31, it's CD 104. Some of this you will have looked at, but probably with a slightly different perspective based on my learned friend's submission. Firstly, the judge defines in the very first sentence what he has to consider. He asks himself the single question, which is did the June determination meet the standards of fairness required by law?
I'm so sorry, it was my fault. Which
This is paragraph 31.
paragraph 31? It's my fault. I didn't get a note of the paragraph because I was busily finding the judgment. Thank you.
So it's page 104.
Yeah.
His question, the question that he defines, the scope of his consideration is, did the June determination meet the standards of fairness required by law? This is the sole issue that he was considering, and it's on its face an obviously fact-sensitive one. He then, obviously, we have looked a little bit at 31 and 32, but he reminds himself as to what kind of approach he should take to answer the question. Firstly, not to take a highly technical approach, and that's line 3 of paragraph 31, and also not to assume and demand that every box is ticked, that's line 4, and that he should be flexible and he should be practical. And at the end of paragraph 31, he does acknowledge as well that some asylum seekers may realise that there is legal advantage to being treated as a child, and therefore the courts need to allow the assessment processes to be robust and effective. No dispute here, I'm assuming, to date, thus far. And we have at 32 also his approach that the depth of inquiry required by a local authority is not binary. He then, cites what essentially Mr. Justice Stanley Brenton said in Merton about obvious cases, the Rainbow spectrum cases. I was just trying to inquire whether or not there's a spare authorities bundle.
Oh right, I think I'll survive. As long as I've got the references, I can always go back and read them.
At paragraph 32, the second
And my lady's
half,
very kindly allowing me to read over her shoulder. Yeah.
Between us.
Yes, between us we'll muddle through somehow.
I'm grateful.
I do apologise. It's my fault for being an idiot. Yeah, sorry. Carry on.
My lady, so the second half of 32 is quite important because it says, once, as in this case, the local authority is dealing with a young person who their suitably qualified staff regard as very likely to be over 18, a shortened process must be permissible. So he acknowledges that it is possible for a social worker to come to a view about the length and duration of this. The dispute between us is when do they do that? And I'll show you from the documents and evidence that was before the court why he makes this comment. But he makes this comment and acknowledges the concession made by the defendant. So it's a concession made by the defendant in the court that once you decide to interview, then it has to be fair. That isn't what I understand. Don't understand that itself to be dispute. The dispute is what the purpose of that interview was for. And my learned friends.
Well, I think there's a certain ambiguity in the precise ambit of the concession, because what does the word fair mean in that context?
Well, yes, and that turns on a dispute between the parties as to what the purpose of the interview was for. And it's our respectful submission that, contrary to what my learned friend says before this court, it wasn't the case that the social worker simply decided from the very outset that this is a very obvious case and therefore not very much needs to be done. And I want to make good that submission by taking you to the witness statements themselves, which I don't think you have looked at in any much at all. And you find that in the supplementary bundle, my ladies, my lord, Miss Hughes' statement is at tab 7 of the supplementary bundle. Sorry, it's page 83.
Can I just pause for a second
Yes.
and just ask a question,
Yeah.
please? Generally speaking, there's a decision, I think, of this court called Ex parte Ermakov, which says that where you've got a reasoned decision, it's not normally legitimate to supplement it or go behind it by reference to witness evidence. So how does that principle fit with this idea that you can look at the witness statements?
Well, it's the witness statement, describing the process, but you
Right.
can also see it from the age assessment itself. So I can take you to both of those documents,
All
and
right.
also to the case that was put before the court
All right.
by my learned friend, because the judge is deciding the case as put by both parties and asking the question of fairness in that context. He's not going off and doing his own exercise of what he thinks necessarily is supposed to be the fair process.
But I suppose one of the points one has to bear in mind when reading a judgment is that strangers to the dispute who read the judgment may take something out of the judgment which is not apparent to, or is the people who are involved in the dispute, or which people who, so a stranger to the dispute has just got the judgment,
Yes.
hasn't got anything else, so doesn't know what material lay behind the statements in the judgment.
Well, I will go to show you in the judgment that he does refer to the material that he looked at. But secondly, in relation to what his benchmark or what he was asking himself in terms of fairness, it is relevant what the case that was argued before the judge was by
Right.
both parties, because that's the evidence and the submissions that he had to grapple with
Yes.
to deal with that. I mean, it might be a shortcut simply to take you firstly to, so Ms. Hughes' statement, if I could just take you to
Yeah.
the first instance. This is paragraph 85, paragraph 10.
So this is in the supplementary bundle.
Page 85, paragraph 10.
So, paragraph 10 describes the process on the day of the assessment, and you'll see the description that they tried to establish that they could communicate with him.
Yeah.
And then during the meeting, we conducted a short form assessment, we made extensive efforts, etc. And then paragraph 11, my ladies and my lord, says during the short form assessment, we explained to SB the reasons why we were during the assessment, we explained why we were minded to think he was an adult and gave him an opportunity to respond. It was obvious to us by the end of our meeting with SB that he was not a child.
Right.
So there is a criticism by my learned friend that, well, he says, well, they took a view that he was very likely, perhaps even 7 or 8 years old. And they no doubt took a provisional view, because that provisional view informed the duration of the inquiry and the depth of the inquiry. But it certainly isn't the case that they simply took that view that is so clear and obvious we don't need to do anything. And Mr. McCrosen's statement at paragraph 9 also states the same. It is essentially identical to Ms. Hughes' statement. In the pre-action response, we were told by the appellant that the interview took 2 hours. And the reference to that is also in the supplementary bundle page 39, which is exhibited to my instructing solicitor Roy's witness statement. It's a the patch and response from the appellant says at page 40 that the interview proceeded for 2 hours. And you'll see in that letter as well that it was the appellant's position that the interview was also to assess credibility.
So where are you looking on page?
At page 40, it's the third full paragraph from the bottom. The assessment was undertaken on the 11th of June 2021 and conducted over a 2-hour period in the social care office. And then the next paragraph, the assessment took into consideration the cultural specifics of boys from the claimant's country of origin, his credibility, and took into account the margin of error for the abbreviated nature of the assessment.
So this is a letter written a month later by the solicitors rather than by
yes, on
social
instructions.
workers.
Yes.
Yeah?
On instructions. And then on instructions in the detailed grounds for defence, is this in the core bundle, page 175. Paragraph 45. Core 175.
Yep. Yep.
Paragraph 45, this is the appellant's case before the judge, which is that the assessment of the claimant is not limited to his appearance, although that is strikingly adult, but also took into consideration the
Sorry, could you just remind me of the paragraph number? It's my fault again. 85.
45.
45, sorry.
45, page 170.
Thank you. I'm several skips behind the beat as usual. Thank you
I
very
do
much.
apologise if
No, it's not your fault at all, it's mine.
But again, what does that add to the actual age assessment? Because you can see references to credibility
Yes, quite.
in that.
Yes, I think the general, maybe long-winded way to provide a response, which is it's simply not correct, and we respectfully submit that it's not correct that the interview was only about demeanour. It's clearly an assessment of credibility in addition to everything
But
else.
it depends what you mean by an assessment of credibility. You know, is it just about the credibility of the claimed age, or is it about, does the assessment of the credibility of the claimed age depend on a further assessment of the credibility of other things?
Well, the
So they're not
credibility-
necessarily the same thing.
Well, their view was that his dishonesty on matters that he provided answers to informed their decision on age, because the entire section of the box, decision on age, not only contained, yes, it contained physical appearance and demeanour, and I do accept that, and I'm not suggesting they didn't take
But I think,
any of those.
surely you can test it in this way, Miss Lou. If you leave out all the stuff about the things they thought he was and wasn't forthcoming about in the interview, say they thought he was forthcoming about all of those, is it really credible to suggest that they'd have reached a different view?
Well, that is what the judge said, that the procedures for relying...
Well, never mind what the judge said, I'm asking you what your submission is about that.
I don't understand the question.
Oh, all right. I haven't expressed it very well. They reached, just summarising the effect of the assessment, they reached a pretty clear view on the basis of his behaviour during the assessment and his physical presentation that he was over 25. Is it your submission that that view would have been changed had they not misunderstood the things which it is your case they did misunderstand?
Well, it is very possible that it could.
All right.
But that's not what this court is here to make a decision about, is whether they could have or should have, is whether or not the judge was, it was open to the judge. It was a reasonable decision open to the judge within the range of decisions that he made making sense of the evidence. Because the age assessment itself under the heading decision on age, it's very clear that they took all of those matters into account, and obviously took a view that none of them altered the issue of physical appearance and demeanour. You can form a very strong impression that someone looks older and seems older, but as all the guidance says, that could be for a variety of reasons, and hence credibility.
Sure. But if they'd reached, if they'd properly understood your client's case about what happened in Malta and which countries he travelled to and from on the way to the United Kingdom, is it really likely that would have influenced the view that they reached on the basis of his conduct in the interview and his physical appearance?
They could decide because of those issues that they might make more inquiries. So they made a decision not to make further inquiries, partly because of the credibility issues. So they stopped the inquiries. We don't know whether or not they would have continued their inquiries, because the only inquiries they made, your ladyship is right that the only inquiries they made were the inquiries that are recorded in the age assessment. But that partly informed why they decided, well, we've made enough inquiries.
But what kind of inquiries do you say they should have made?
They could have said, well, tell us a bit more about, the peer group that you were with in Malta, what age they were. They could have said, they could have asked him a lot more questions about his life in Sudan. I'm not the assessor.
No, I'm just asking you what your submission is.
It's the kinds of things that Mr. Justice Stanley Burnton says at paragraph 27 and at paragraph 28 to 29 of his judgment, which is, if you're going to elicit a history, then you need to elicit a history that's relevant to age. But obviously, if they decide, well, I don't think you're credible, and I don't think asking any more questions would actually help me, they may not go on to ask those questions. That's the difference, is I can't predict what it is that they may ask, but it's clear that Nanton did a fuller assessment with a neuro interpreter, with an appropriate adult, and they came to a different conclusion. Whether we like it or not, that's the reality.
I mean, doesn't this really amount, though, to saying the whole short form procedure is inherently faulty? Not what you're saying. I mean, but
no, it's not.
because the authorities clearly establish in clear cases that's all that's necessary.
Well, I think
right?
what you haven't been taken to is where Mr. Justice Swift in Ham has a very specific analysis of short form assessment and full assessment, because the issue that was at the legal principled issue before him was the issue of, well, does a short form assessment inherently mean a reduced list? You sort of reduce fairness by virtue of being short. And he perhaps this is, whilst we're on this point, it might be just worth just having a quick look at what he says, because it's actually quite important to have that in mind, considering what is meant by a short form assessment.
Yes, thank you.
And that's at tab 11.
I've just realised, to my embarrassment, that I have got the authorities bundle after all. I've got it open at a page which made me think it was the supplementary bundle. So I'm sorry for all the inconvenience I caused everybody by being, once again, several skips behind the beat. Right, so that's tab 11.
Well, I'm glad we're all on the same page. Tab 11, page 207. Bottom of the page is headed short form assessment. It might be, if I could be asked to read it, the court could read 22 to 28, I would be most grateful.
Yes, of course. Maybe we should carry on reading this passage because
Yes,
it's all quite important, because he then, Mr. Justice Swift then goes on to say what he thinks the correct position is.
yes, I do apologise, yes.
So this is the context for the remarks that we were shown this morning.
Right.
Yeah. Yeah. All right.
So, I mean, the essential points extracted from this, essentially, there's no fixed idea of what a short assessment looks like and what a full assessment looks like. A short assessment could, as Mr. Justice Swift says at paragraph 25, could be no interview, one interview, several interviews.
Yes, in other words, what he's saying is that what's required, what fairness requires in each case, will depend on the facts of each case.
Yes,
in
and
short.
that's also precisely what this judge says, as your ladyship had picked up, and you will have seen at paragraph 31.
Yeah.
Mr. Justice Swift refers to the judge.
No, I mean, we're all clear what directions this judge gave himself. That the issue rather is, firstly, whether he followed those. Now, that might not be an issue that entitled this court to hear an academic appeal. But I think there might be a further issue, which is how the judge's decision will be understood by people who aren't familiar with the details of this dispute, and how his decision will be understood in the light of the fact that his decision has been endorsed in two separate parts of Mr. Justice Swift's judgment.
On the latter point, my lady, as you said to my learned friend, the two parts of his judgment that are endorsed by Mr. Justice Swift are points of principle that actually aren't in dispute. So
yes.
That in itself wouldn't be a basis for an academic appeal to go ahead, because it would only be relevant if there is a conflict as to, well, what is a local authority supposed to do by way of a principled approach. In relation to the judgment, I mean, it is necessary, therefore, to take the court to what he actually says in each and every aspect that he makes findings on, because that is what this appeal turns on. So if but I just want to make one further preliminary point, which is that, as you can see at paragraph 32, he does respect the assessor's decision to take a much shorter approach.
Sorry, you're back in
sorry,
to the judgment
yes,
below
You're
here.
quite right. My lady,
Moved
I do
away
apologise.
from-
It's paragraph 32 of the judgment, and it's page 103.
Right, sorry, just give me 2 seconds, please, to find where I've put the judgment. So this is paragraph 32 again.
Paragraph 32 was what we had been looking at when my lord asked me the question about shortened assessments.
Yes.
Yeah.
And I was simply drawing the court's attention to what he says there, which is that suitably qualified staff, so these 2 assessors, made a decision to take a shortened process. He doesn't criticise that.
Well, wait a minute. Just let me just read it again, please.
It's probably 5 lines down.
1, 2, 3.
It says once,
5.
as in this case.
Yeah. Yes, but I mean, but that slightly begs the question, doesn't it? A shortened process must be permissible, but it's still got to be fair. Yeah.
Yes. So, but as Mr. Justice Swift said, well, every assessment has to be fair on their own circumstances. So you have to consider what is fair.
Sure, but I mean,
So
an ignorant reader of this judgment, which, as I say, has been endorsed by the lead judge of the administrative court, might read this judgment as deciding that even if it's permissible to have a short form assessment, it will be unlawful if there isn't an interpreter and there isn't an appropriate adult and there isn't a minded to process. I'm not saying that that is necessarily what the judge actually decided, but we all know how the ways in which people refer to judgments. And that might be a risk, is all I'm thinking.
Perhaps on the appropriate adult point, which I'll come to shortly,
Yes.
I will take you to your ladyship asked the question, where does this come from?
Yes.
And I will take you to that in due course, just
All right.
so you understand that obviously this judgment doesn't stand in a vacuum from the other judgments, and they all
No.
have to be looked at in totality.
Sure.
But the point about fair procedure, as the court will be very familiar, is what is fair is a question of law. So obviously the primary decision makers have to have themselves in mind that when they set out to do something, they should do it fairly. But whether it is fair is a question of law. And Mr.
Well, it's a question of law for the court.
For the court, yes.
And it's not a reasonableness question, it's a question that the court decides.
Yes, quite. And taking an approach of considering for himself whether the assessment process is fair doesn't necessarily on its own mean that he ignored the social worker's decisions, because the two are not binary. Just because you respect social worker decisions doesn't mean that you take everything at face value and therefore think that they must have done everything that is fair if the evidence shows otherwise. So obviously he can't decide for himself something speculative, but he can look at the evidence that was before him.
Yes.
And we say that's what he did. So on that basis, could I just maybe drill down to look at some of the specific things that he found? Because obviously, I understand the court is concerned about him laying down any general principles that might be misconstrued.
Yeah.
At paragraph 33, he looks at the interpreter point. If I can put that in short. And he acknowledges the social worker's views. And he actually records the factual evidence. So this is his discussion, but in the earlier part of the judgment, at paragraph 8, he records the factual evidence that was available to him from the parties in relation to what happened on the interpreter issue. And you'll see that he acknowledges that they took all the steps that they did, and that's not in dispute.
Yeah.
However, at paragraph 8, sort of halfway down, 8 lines down, he says, there are various reports and notes and statements stress how the claimant seemed proficient and confident in English, but I note there are even in their own documents some grounds for at least a degree of caution. Mr. McCrosen, for example, wrote in his notes of the claimant speaking English with next to no difficulty in Miss Hughes's handwritten notes. So these are documents that were adduced by the appellant and exhibited to the social worker statement of contemporaneously. There is an entry that reads, became emotional, could be because of stress of the meeting, lack of interpretation, or speaking about family. The claimant, by contrast, in his statement prepared for the litigation, I tried to speak English, etc. So,
Yeah,
so that is...
so he's recording material in the notes of each of the two assessors, but the assessment, which records their decision, is the document that they put together, presumably having, on the basis of each set of notes, having discussed it between them and reached conclusions.
Yes, but interpreter obviously is not something that you fix at the end of the assessment. You either have one or have one at some point in the assessment. It's not some a safeguard, for example, a fairness safeguard that you can fix as a rear guard matter. It's something that you decide both at the beginning, but we would say at some point if it became apparent during the assessment.
Yeah, but the judge isn't here saying, all he's saying is grounds at least for some degree of caution. He's not saying that the conclusions that they reached are Wednesday unreasonable.
Well, can we? No, he's not. He's recording the facts here.
Yeah.
So he's not making commentary on the facts here.
Well, he is making a comment. He says some grounds at least for a degree of caution.
Well, he's making some. He's observing that their notes seem to indicate that although they say at the beginning, everything seems to be fine, there were some concerns during the assessment that may have been because of an interpretation issue.
Right.
So you take that and then you go back to paragraph 33. At the top of paragraph 33 over the page at 105. Then again notes that there's one possible cause for the claimant becoming distressed was the lack of interpreter. And then he also notes that some of the matters that the social workers relied on to undermine the claimant's credibility are the sorts of comments that could be explained by lack of verbal precision. And that is one of the issues is whether the passport that he travelled on was a passport in the language of Nur.
But is that issue referred to in the assessment?
It isn't, but it's an issue that was taken up by the local authority in front of Mr. Justice Bennathan as an issue for why credibility was found to be unaccepted.
Right, but it's not referred to in the assessment.
No, it isn't referred to in the assessment. But it's well, we don't know whether or not it contributed to a finding of dishonesty, but because obviously they make an overall comment that he is not. So they say the respondent wasn't completely honest with us about things that make us believe that he is more likely that he might be also dishonest with us about his age. So that's the general finding that they make in the section called Decision on Age.
Yeah, okay.
And it's in the contemporaneous notes, so they would have looked at that for their discussion. And if I could just, so that is an issue of in Nur, the language, or in the name of Nur, because it's a common name for people from his area of Sudan.
Right.
And that is the sort of difference that an interpreter, he says, could make a difference.
Yes, I understand the point you're making. The only point I'm making is this isn't referred to as something that influenced the assessment because it's simply not mentioned in the assessment.
Yes, but
which is, the assessment is the reasons for the decision. That's the primary document that we go to when we're considering.
I do understand that, but if this is an issue that he addressed because it's an issue that was relied on by the appellant, maybe he shouldn't have indulged the appellant in saying, maybe that was
anyway,
a mistake.
All right.
But it was an argument that was put forward in support of the appellant's case, and the judge dealt with it, because otherwise, one could also say, well, I made this argument and you didn't deal with that. There are
I
many
didn't deal
different
with
ways.
it because it wasn't referred to in the assessment. Anyway, yeah. All right.
There are multiple different ways in which that can happen. I mean, if I don't want to go beyond what the judge is saying, but if you were to look at another example that he refers to in the context of the minded to an appropriate adult, because it feeds into the whole picture. One of the points is about whether or not why he had a picture of him in Malta sitting on a sofa when he was in detention. So that the age assessment deals with this at page 257 and 258, and I don't propose to take you to that.
Yeah.
But in his witness statement, which obviously was before the learned judge, he deals with this issue at his witness statement, and actually, it's noted in the judge's judgment. I do apologise. So that's probably the best place to look at. At paragraph 12.3. That's page 98. So this is about the dealing with the images from Malta. The claimant states that after initially being detained in restrictive conditions in the army barracks, he was moved to a second establishment, and then he was moved to an apartment where he was pictured with images from Facebook. And in his witness statement, and I could just take you to that because obviously that's relevant because this was a case where there was no we say there was no minded to. His witness statement becomes a relevant consideration. You find that at tab 3, if I may, of supplementary bundle, paragraph 19 and 20.
Sorry, you have to give us a page number.
Page 21.
Okay.
Oh, sorry. I apologise. It's actually the witness statement 1. I do apologise for that. It's witness statement 1, page 9, paragraph 19 and 20. Page 9.
And he exhibits a photograph of the camp. Is that right?
No, it's a photograph of the apartment or a flat.
Well, actually, no, it's not. I think actually there is a photograph of the camp.
This photo is of the detention centre.
Yes, that's what I said.
Yes.
Sorry, which page of the bundle was that?
It's a supplementary bundle.
Oh, right, page 16. Yes,
page
got it.
16 is the detention centre.
Right.
The paragraph that I wanted to draw the court's attention to is at page 9, paragraphs 19 and 20. And you'll see he describes first being in barracks, which were restricted for 10 months, and he exhibits that photo. And then he was moved to a camp, which was more flexible, and he was allowed to go out. He stayed there until the end of the first month, and then at the beginning of the second month, he went with friends to an apartment. Sometimes it's a semantics of with, to, those types of things in the context of people who inherently don't speak English as their first language. That's a relevant issue that is prone to misunderstanding, which obviously the court deals with in the context of minded to, but equally could be looked at because he looks at the whole picture. It could be prone to misunderstanding. You went to a friend, with a friend.
Does he suggest he showed the social workers the picture of the camp?
I don't think so,
Right.
because I think they were only asked him to show them his Facebook.
And this wasn't in his Facebook account?
No.
Okay.
Well, I mean, do we get any more from this than the fact that I mean, your client came up with an explanation to deal with what, on the face of it, was a very valid point being put to him, which is, he said, I had a terrible time in Malta. I was detained for 10 months, did you say, in a camp. And then then it turns up there's a photograph showing him apparently entirely at ease, sitting in a rather well-appointed apartment. So there's obviously a very big question about his credibility as a result. And he comes up with an explanation, but then it was a matter for the judgment, presumably, of the social workers as to what weight, if any, they attached to it. And they obviously weren't impressed.
That would only be right if that was put to him. But as a judge found, it was in paragraph 39 undermined to. So, my Lord Justice Henderson, you're entirely right that they should put to him those questions. I mean, but they didn't. It's not.
Well, doesn't that slightly beg the question as to what is the degree of fairness required in this kind of a case? I mean, if fairness requires all the paraphernalia of what you might call a full Merton assessment, then obviously it did have to be put to him. If, on the other hand, this was really a kind of very subsidiary fine-tuning process to put as a kind of check on their very clear initial decision beyond the realm of doubt that he was over 25, then was it not open to them just to note that there was this discrepancy which turned up in the course of the interview, for which, in their view, no satisfactory explanation was given? And the absence of a minded point, no doubt, detracts or might detract somewhat from that, but does it actually fatally flaw it?
That would be a significant departure from all the established jurisprudence, even in short assessments. My respectful submission is, as a matter of principle, fairness requires an opportunity to deal with not just any and everything, but this was an issue that was squarely set out as a basis for the dishonesty finding in the age assessment. Your Lordship would be right to say, well, they didn't put the passport issue to him, but they didn't refer to it in the age assessment. But certainly this is an issue that was very much in the paragraph under decision on age. That was one of the key points. And so it is an issue that they should put to him. I mean, that is a sort of minded to point that isn't quite the interpreter point, but as your Lordship is right, that all of it fed into the judge's assessment of whether this assessment was fair.
Right. So are you saying, among other things, that even in a short form assessment, one of the necessary requirements is a minded to stage?
Well, I mean, I'm not
at least where credibility is an issue.
I'm not making any general principle.
Well, sorry, I just wanted to clarify because I got a hint that you were saying
no,
that.
I wouldn't say that. But the judge also didn't say you have to have this or you have to have an interpreter, because what we didn't look at is paragraph 34 of his judgment, because this is still an interpreter point. And at paragraph 34, he doesn't say, well, that's it, it's unfair. He says, this was a significant shortfall. In and of itself, by itself, it wouldn't necessarily have been sufficient to render the process so unfair to be unlawful. So he isn't saying you have to always have an interpreter.
No, but what he's going on to say is, coupled with the other two defects that I find in this case, it was.
Yes, so he's looking at fairness in the circumstances of the individual case and giving the reasons. I mean, you've got to look at the judgment in its structure. He says, well, I'm very concerned about the interpreter, but does it on its own can I stop there and say, well, that's it, it's unfair? And he says, no. He says, well, it depends on whether or not those problems that may have arisen could have been mitigated by other steps, such as an appropriate adult or slower and more thorough minded to process. And that's why he then goes on to look at appropriate adults and the minded to in a fairly structured way. He doesn't put down a principle of any sort, and his judgment, in my respectful submission, doesn't lay down a marker that if you don't have an interpreter, it will be an unfair assessment. In the same way that Mr. Justice Swift, consistent with this judge, says, well, it depends on the circumstances. So each judge has to look at the circumstances in front of them. That's why conclusions can be different.
Just pausing here, though, that if you have another case in which the view of the social workers is that a person is obviously over 25, could this judgment be read, but their first language isn't English, could this judgment be read by an incautious reader as deciding that in such a case you would be required to have an interpreter and or an appropriate adult and or a minded to process?
I think if I were to advance that case in front of Mr. Justice Swift, I would get short shrift doing that.
Okay.
Because it's very clear that it depends on the circumstances.
All right, can I just get a note of that? So this judgment could not be read as deciding that if first language not English and social workers decide obviously over 25, requirement for interpreter and or appropriate adult and or minded to process. That's your submission.
Yes, and could I give you also, this is supported by the analysis of Mr. Justice Stanley Bounton in Merton, because he deals with a very similar scenario of an interpreter. In that case, it was an interpreter on the phone.
Yeah, but I'm not asking you about Mr. Justice Stanley Bounton's decision primarily. I'm asking you how this judgment could be interpreted by other people.
Well, my point is, in the same way that in that case, the interpreter point fed into the unfairness of the judgment, it's a 2003 judgment. No one has since then said, well, Merton says you have to have an interpreter, and if you don't, it's unfair. I don't think the reasonable reading of this would come to the same conclusion. It is very clear from this judge's principal approach that everything depends on the circumstances, and so therefore, well, in my respectful submission, an administrative court judge looking at this will say, well, Ms. Liu, he looks at it on the facts of the circumstances of the case. He doesn't say it will render it unfair. He expressly says it would itself not render it unfair. So it's quite difficult in my respectful submission.
Well, but what he does say is that those three things taken in combination did make it unfair.
But he says it on the facts and circumstances of this case, and he looks at it, and we can go on to look at the appropriate adult, and I'll try to make good my point.
All right.
Again on that.
Okay.
So on the appropriate adult point, he starts his judgment at 35, but your ladyship had asked a question about the evidence on appropriate adults, and that's at paragraph 9 of the judgment at 96, and it was accepted in front of the judge that there wasn't any question about the opportunity to have an appropriate adult, and that's very clear from that.
Right.
So that answers the factual question that I think.
I'm not sure I did ask a factual question.
No, I think it may have been me.
Adult.
Justice
sorry.
did ask that question.
Oh, okay. I'm so sorry. I thought you were talking about me.
I was trying to answer
Yeah.
all three questions.
No. Sorry, my fault.
Thank you.
So factually, he wasn't offered an opportunity.
Yeah.
And my Lady Justice Laing asked, well, where does this issue about appropriate adult come from? And you may be familiar with this court's judgment of FZ and Croydon. That is at tab 8 of the authority. Sorry, tab 7 of the authorities. Let me start again. Tab 6 of the authorities.
It's all right. Don't worry at all. I've been completely hopeless on practical issues in this hearing. So
trying to juggle.
Yeah, no, I understand.
Bundles is quite difficult. So you're familiar with the permission test in FZ, but it also dealt with a couple of principal issues, one of which is the appropriate adult issue.
Yeah.
And you'll find that in the judgment at paragraph 23,
Yeah. So so can we just sort of get our bearings? What was the issue in FZ?
FZ was a challenge to an age assessment done by London Borough of Croydon, where when they told him about the assessment, they only gave him a fact sheet. So what used to happen is they would have a fuller document and they'd go away and type up later.
Yeah.
On the day when they tell the person, they give them a back sheet with some reason. Not dissimilar to sort of, it's a slightly shorter form of the form that you see in this bundle. And they say, well, these are the short reasons that you are, your age is not accepted. So in that case, there was a permission refusal.
Sorry, it's tab 6. Yeah.
It's tab 6.
Yeah, no, my fault, I got the wrong tab.
It's a permission refusal, an appeal on a permission refusal.
So it's an appeal against a refusal of permission to apply for judicial review?
Yes.
Right.
And just to give you the marker chronologically, it postdates A in Croydon and the fact-finding jurisdiction.
Yeah.
So it's 2011.
Yeah.
And obviously, if permission is refused on a renewal, then you're shut out from a fact-finding.
No, I understand. So you go to the Court of Appeal and you say, I should have been given permission to apply for judicial review. My claim was arguable.
Yes.
So was the issue that the Court of Appeal were considering this case whether or not the claim was arguable?
Yes.
Right. All right.
So you'll see at paragraph 5 of the judgment, it says the judicial review claim challenging a local authority assessment may be made on various grounds. Some may be orthodox judicial review grounds, others may be fact, a challenge to the fact.
Oh, I see that you were the junior in that case. Further evidence of your enormous experience and expertise in the field.
I wouldn't purport to claim that. At paragraph, so the appeal analysis starts at 18.
Yeah.
And you'll see the 3 main issues that the court had to deal with. One is about
I suppose we ought just quickly to look and see what approach the judge took up in refusing permission to apply for judicial review.
The facts start at 11.
Yeah, no, I think there's a summary of what the deputy judge decided at paragraph 17.
Yeah.
Yes, you're quite right.
Yeah. Yeah. So he concluded there was no realistic prospect that the age assessment would be quashed on procedural points alone. All right. Yep.
At 18, you'll see the issues for this court set out. There are 3 main issues. One is the issue of response to provisional adverse findings. So that's sort of shorthand as a minded to. And then second is the appropriate adult point. And the third is how the court should address the question of factual issue of the young person's age is arguable. Because this is quite early on after the A and Croydon judgment. So
Yeah.
the question is, what is the permission threshold? Is it the same? Is it different? Is there a different question? But on the 2 principled minded to issue and the appropriate adult issue, if I could just take you to the appropriate adult issue first.
Sorry, I'm so sorry to interrupt again. Can I just ask, what was the authority's view about the age of this person?
17 plus.
17 plus.
17 plus, all right. Thank you. Yeah, sorry, do carry on.
That's okay. At paragraph 23 is the appropriate adult. If I could just ask you to read the 23 and 24.
Yeah. I mean, one of the facts here was that at the time of the assessment, the claimant claimed to be a child, and at the time it was agreed that he was one.
That is right, yes.
Yeah.
But this court was looking at the matter of principle, what needed to be done.
Yeah.
Because obviously you could very easily at the beginning of a process meet someone and go, wow, you really do look over 18 quite a bit, but decide nevertheless to carry out an interview to see whether or not at the end of it you still think that. Because as Ms. Rowlands has taken you to in Merton, you know, physical appearance and demeanour is said to be notoriously fragile. So if you're not just going to make
except in a clear
right
case,
then that you're not going to do anything else, then you need, if you're going to make inquiries, that's when fairness arises. I mean, I don't want to repeat the point I've already made the submission on.
Yeah. All right.
But you see, you asked the question about where there's this principle about appropriate adult.
Yes.
So what this court said was not that you have to have one, but you should be given the opportunity. We don't push it any further than that, and it wasn't argued to be further than that. But
this court wasn't making a final decision on the claim. This court was making a decision about whether the claim was arguable. So it may have expressed itself in terms that suggest it was deciding an issue of law, but was it really? When it was deciding whether or not this claimant should have had permission to apply for judicial review.
No, that's right. But he was deciding. They were deciding at 18 whether the local authority should, in fairness, offer the young person the opportunity to have an appropriate adult. It was a point of principle that was on appeal. But then it was looked at again by this court in another case. So this court has already looked at this issue, and it's tab 8.
Right.
This is a case called ZS.
Yep.
It has a very complicated history, to say the least. But there are various other problems with the factual procedure of this case, where they challenged an assessment out of time, and there were various other assessments and other documents.
So was this a decision after a final hearing or a...
This was a judicial review decision. This is an appeal from a substantive judicial review judgment.
Yeah.
So it's not a permission decision.
Right.
And you can see that paragraph.
No, I've just seen that. Yeah. Okay.
I just for the history of this and the decision under challenge. What's relevant about that? The decision under challenge predated this court's judgment in XZ, and that becomes relevant when I take you to what this court said in ZS.
Right.
And the independent, the appropriate adult point is at paragraph 48, page 157 of the authorities bundle. So this court took a sort of historic review of the development of the issue, and noted that Merton obviously didn't mention appropriate adult as a requirement, desirable factor in relation to appropriate adults, but in other cases this was mentioned. And then you see at paragraph 52 and 53 what this court came to the conclusion of on review of those documents.
Sorry, the appeal was so at the end of paragraph 8 it says the appeal was dismissed. Is that intended to be a reference to the application for judicial review?
Which paragraph are you?
Sorry, it's just the last sentence of paragraph 8. There's a description of what happened at the hearing and the judge's conclusion.
I think it's meant to be...
The application for judicial review.
No, let me just double check that.
Or is this a reference to a different
This
thing
is a
altogether?
first-tier tribunal immigration decision, because you can see the next paragraph.
Oh,
my
okay.
lady. So it was about his immigration appeal, where the age issue also cropped up there.
Oh, I see. So there was a decision by the FTT about his
Yes.
age.
So that's why I said
Right.
that
It's factually
it's
complicated.
a very complicated factual case.
Yeah.
But I am only showing this case to the court in answer to show how this court looked at the requirement of appropriate adult.
Yeah.
And you get that at paragraph 48 to 50.
Right. So a lot of procedural water flowing under the bridge. I
Right.
see there's reference to a detention claim
Which
as well.
is why I hadn't
Yeah.
bothered to.
No, I understand. It's my fault for getting into the weeds too soon. Paragraph 48. Right, an independent adult. Right, so there's no reference to independent adults in Merton
Yes.
or the Hindu guidelines. Yeah.
And then there's a case of RA and Collins, and I believe you have that in the bundle as well. But certainly NA and Croydon in paragraph 49, halfway down.
Right.
NA Croydon is in the authorities bundle for your reference at tab 3.
So it's an aspect of best practice according to Mr. Justice Blake. Yeah.
And then they deal with FZ. They refer to it as Z.
Does this case or FZ discuss the scope of the age assessment, or is it assumed in both cases that what you've got is if you like, the full works?
I think the term abbreviated versus full assessment reared its head in AB and Kent as one of those cases.
So later on.
Yes, much later on.
Okay, I just want to understand the context,
Of course,
because
of course.
This case 52
So
is endorsing Z as saying that you should offer the opportunity.
Yes, you're quite right, my lady. But what I will take you shortly after this. I want to just take you back to the ABCS guidance, but then I want to take you to TAM, because Mr. Justice Swift then deals with that in the context of short form assessment. That might assist the court as well.
all right. So in paragraph 53,
Yes.
Lord Justice Bennett, as he then was, said, indicating evidence doesn't support the proposition the appellant not offered, even if he was not. I do not accept that by February 2009 the term Merton compliance was understood to include this requirement.
So because the assessment that was under challenge was from February 2009.
Yeah.
But 52 certainly reads as though, well, the third sentence reads as saying by the stage of 2011.
Yes, so what it says, it doesn't say you have to have one, but
No,
it says
the
you have
opportunity
to
should.
to give one. And so in FZ, I don't want to look back there, but my essential in FZ, if you read the text of it, he did have a friend come with him. And in the case that my learned friend relies on, called AK, which is Lady Justice Andrews when she was in the lower court. That was a case where she decided on the facts that didn't make a difference, but it was a case where he was offered. And so paragraph 33 of the perfected skeleton sets out the Lady Justice Andrews' judgment in that case. And
That is your skeleton? Or?
It's my learned friend's skeleton. You recall she
Yes, I
refers to
do.
that.
I do. Yes.
And she refers to that passage of that judgment. And if you read those passages are the relevant passages. And in that judgment, Lady Justice Andrews, when she was in the lower court, said in that case, on the fact he was offered to bring a friend who would inevitably be an adult, but he declined. So in terms of the kind of baseline of offering.
But the point I'm struggling with is whether ZS goes any further than saying, in circumstances when the person has got mental health problems and was agreed to be a child at the point when the assessment was done, he should have been offered an independent. He should have been asked whether he wanted an independent adult present. I mean, how can that case be? And I'm not even sure as a matter of precedent it can decide that, because all they were considering was whether or not the claim was arguable.
Well, my lady, could I perhaps on that basis, it's worth just looking at Ham.
Yes, please.
Yes.
Justice Ham. I can see the inkling from the court that you want to look at that. But
Well, I may have misremembered, and you'll find out very shortly, but I think I remember the judge saying with some hesitation he accepted it was not
yes, you're
an
quite
absolute
right.
requirement.
Yes, and that was what I felt I had to take you to, but to the context in which he
Yes.
said that as well, because it's all about context.
I know,
as
but
well.
I'm just standing back. That must surely be right, mustn't it? I mean, to suppose somebody of my sort of age went along claiming to one of these
Yes.
interviews, claiming to be under the age of 18. I mean, if they didn't send straight away for medical assistance,
Well,
I can't believe if they just questioned me a little bit about what I was doing,
I'm
that
not,
I would need to have
I hope I don't
the offer
cause,
of a.
I hope not to cause offence, but
of
I'm
an
not sure
adult.
they would even ask any
Well, I hope they
questions.
wouldn't. I mean, I'm sorry. But we're in an area where some cases are so obvious, it's just a matter of blinding common sense. If you're a baby in arms at one extreme or somebody on a Zimmer frame of very great antiquity at the other, it's just not going to work.
Or someone of the antiquity of my antiquity. Let's go no further than that.
There was a judgment some years ago from Mr. Justice Mumby, as he then was, in a slightly different context about age assessment and detention. And he does make the comment that, well, if I walked in and asked for an age assessment, obviously people would laugh me out of the door.
Yeah.
And I get that, but there's a spectrum that we're talking about
Well,
here.
all that means is you can't have absolutely firm, absolute rules.
Well, and I don't suggest that. I'm not suggesting that you do. I'm just taking.
You're just giving us a survey
Yes.
of the relevant
Yes,
case
I
law
don't
because
push
I
my
asked,
submission.
where does it come from?
Yes.
Yes, so
and
sorry.
No, and you're being very helpful.
And patient, I must.
I don't want to be misconstrued as
No.
beyond our respondent's position.
Yeah, I understand.
Paragraph 20 of Ham, which is 206 tab 11. I believe this is the section that goes on to the next page. This is the section that my Lord Mrs. Henderson is remember. Page 206 internally, and it's 1790 internally in the judgment format. So what he says, draw your attention particularly to 1791C, so under letter C, says, it seems to me, not without considerable hesitation, it seems to me that the stage hasn't yet been reached when an interview conducted without the opportunity for an independent adult to be present will, without more, so I do emphasise without more, fail to comply with the legal requirements of fairness. And then he looks at FZ, and he says this example alone does not warrant a one-size-fits-all. And then he looks at the ADCS guidance, which we looked at briefly this morning. And then he says, I do not consider this professional guidance to be sufficient to give rise to a legal requirement that an appropriate adult must be present. That an adult must be present, not just even opportunity, but must be present.
Yeah.
But then he says, whether or not fairness requires the presence of an appropriate adult should depend on the circumstances of a case.
Yeah.
And what needs to be considered is the functional importance of the opportunity to have an appropriate adult in the case. And my lady, you are my lady Justice Laing, you asked the question, well, what happened in that case? So Mr. Justice Swift decided on the circumstances of that case that an inappropriate adult, not offering the opportunity of an appropriate adult, wouldn't have made a difference. So the question is for each judge to look at it again. That central theme that isn't actually in dispute in this case.
So was this a case in which Mr. Justice Swift was just considering a procedural challenge, or was he also considering the merits?
So he was considering, this is a very, well, I wouldn't say it's an odd case, but it did have a procedural quirk to it, which is, you've looked at the remedy side of things, but basically in this case, the parties between them agreed that this could go off to a fact-finding hearing.
Right.
And so therefore, he was looking at this as a substantive procedural argument, but then he also decided on remedy because he was agreed by the parties.
Sorry, I'm confused.
It is very complicated.
Yeah.
You can see that paragraph 54 of the judgment. You were taken to parts of it, but it might just be worth looking at it in a systematic way. Well, actually, you weren't taken to this on the relief argument.
Yeah.
So 54, he says, I consider submissions made. My conclusion is the appropriate relief will be in the form of a declaration. So he makes a declaration on the procedural matters. And I think in order to understand that, my lady, if you look up 2 paragraphs, that's 51.
Right. I'm just continuing reading paragraph 54 just to see what he said about that.
So you see at F, as already stated, the parties are agreed that part of the challenge concerning the
Upper tribunal will decide whether the material claimant was a child. Better the decision made sooner than later. He didn't accept the submission that the upper tribunal would be starting from a false premise.
But it did make a declaration, nevertheless. And the reason for the declaration is on the next page, my lady.
It rather begs the question of what the point of having a distinct procedural challenge decided is if, in any event, the merits are going to be decided by the upper tribunal.
Well, sometimes it takes quite an extended amount of time before a fact-finding hearing does get on in the upper tribunal.
Yeah.
So the timeline could be over about a year before an agency.
But you're just increasing the delay if you have a distinct procedural challenge and that succeeds, because then I have to go
Not
back.
Not necessarily if a reassessment is then, if the local authority decides, nevertheless, in the meantime, to carry out a reassessment.
Right.
Or in this case, Southampton, on the basis, Southampton's original position was, well, your findings with Kensington and Chelsea, we're entitled to go with whatever they decided. Once that fell away, they did their own assessment, took their own view, and that took a matter of months. But if this had gone to a fact-finding, we'd probably still be in a fact-finding situation and not been called on. And for children who are, or young people who are 17, going to turn 18, oftentimes the delay means that they age out and not necessarily in the local authorities' care for the entirety of their childhood. And then you've got the GE Eritrea point, which is, well, you age out, that's your problem. You might be able to ask us potentially in a given case to exercise the discretion, but we don't have to.
No, okay.
So there are various issues that.
So what Mr. Justice Swift decided was it was sufficient to make a declaration that there'd been a procedural failing and that the substantive age assessment in the upper tribunal should continue its course.
Yeah, so he decided that because there was two tracks in that case. One was the procedural, but then they were going to have a fact-finding.
Yeah, no, I've grasped that, yeah.
They were going to hear the facts.
Yes.
And AB is also a similar type of case where there was a fact-finding that was agreed by the parties as well. So they agreed at the conclusion of the judicial review that a remedy was to crack on with an extension of the proceeding, so to speak, in a fact-finding context.
Sorry, can you just show me that, please?
It was transferred to the upper tribunal.
Sorry, which paragraph again?
58.
58, and then at the end of that paragraph, so in that case, it was pleaded as both procedural and a fact-finding. For whatever reason, Mr. Rule got refused permission on the fact-finding. So the issue of procedure came before Mrs. Justice Thornton. And you can see that at
Yes. Yes, because it makes no sense to grant permission for part of a JR in age assessment. You're granting permission for the claim generally. And the normal assumption is, once permission's been granted, it will go off to the upper tribunal for them to make the fact-finding. Okay, that's very helpful. Thank you.
Can I go back to appropriate adult?
Yes, I'm so sorry. We keep asking, it's mostly my fault. Keen to understand how it all fits together.
So just going back to my specific point on appropriate adult, we've looked at the ADCS guidance, and I think this court has picked up both, all three judges have picked up on the idea that you can intervene in a procedural way. You can't intervene to say, well, no, actually her answer is this. That shouldn't be of a dispute, and we say just on that particular point, the judge was right to say that my learned friend was wrong, that an appropriate adult can't interfere, because you've got to look at his reasoning in context of what he says at paragraph 37. And he explains what he says there. And before we go there, the one point I also want to make is, and you'll pick this up already from the ADCS guidance, is one of the roles of the appropriate adult is also to take notes, to take their own notes in addition to the social worker notes. And that becomes, we say that is relevant to our submission as well. And the second point also is, I know that the court has already picked up on PACE in the Home Office guidance. It's not materially different, but also the ADCS guidance itself refer to PACE as another helpful guide on kind of the role of the appropriate adult, as does FZ in paragraph 23. So it's not to say it's got to be absolute mirror image, but those are relevant, established, accepted practices that are the kind of things that an appropriate adult will do.
Right.
So if at 37 of the judgment, and that's page 105, you can see what the judge says there, he records, take one example. So he's not saying that this is the only way, but in the judgment he gives one example of why he comes to the conclusion he does. The formal record of the interview says when SB...
I'm so sorry, can you just give me a second to catch up again? Which paragraph of the judgment?
Paragraph 37.
37, yep,
Page
thank
105.
you. Yep.
So he says when he systematically went through the countries that he travelled to see what he says, he didn't mention Egypt.
Yeah.
The social workers then saw a photo on his Facebook account. Says this contradicts what he told his assessors.
Yeah.
Now, just so that you have it in your note, this is also not just it's the formal interview record, so that's page 257 of the age assessment, so that you have that as your note. Then the judge says, well, in his statement for these proceedings, he denies this was a change of story and states that while he had gone on a visit to Egypt from Sudan, that had not been part of his journey, as he had returned from Egypt to Sudan. So basically his account is he had tried once to leave Sudan. He went to Egypt. It was unsuccessful. He went back to Sudan. And then he went on another journey, which is the journey that he took to arrive in the UK. And what the judge said is, it seems to me this is a sort of confusion which, if genuine, could have been helped by an appropriate adult, ensuring such a misunderstanding was not held against him. And what he says is particularly by reference to the evidence, and that's Miss Hughes's notes, which notes that he did say he went back to Sudan. So it is in the social worker's note. It may be a genuine mistake, it may be some other reason, but it was in the notes, and you can see that reference that is in the judgment in the supplementary bundle, page 92. Page 92, I hope you can see 18 July 2019, Egypt then went back to Sudan. So that's in the actual notes. So, but that isn't then recorded in the assessment. It is a matter that was relied on for his dishonesty. And so you may ask me, well, so what? What difference does it make?
You've anticipated the rhetorical question extremely accurately.
Firstly, we say on that specific point, the appropriate adult could say, well, my notes say something different.
Yeah.
They say he went back to Sudan, so why are you saying that he lied about that? Or he changed his story? He didn't. You asked him, he told you.
Yeah, okay.
So that's an obvious point. And then another point an appropriate adult could do, because obviously the judge only gives one example, but he also gives an example in the interpretive context of distress and emotional distress of the of the claimant, respondent, sorry. And in the notes, if we still have the notes open, the notes at page 91. Page 91 of the notes.
Yeah.
The supplementary one.
Getting there slowly. Thank you.
You'll see a little asterisk at the top. It says became emotional, could be because.
Yes, I think you've referred to this.
So I've referred to it, but that's where it comes from.
Yeah.
And again, looking at the ADCS guidance, well, if the person looks stressed, an appropriate adult can say, well, do we want to take a break?
So yeah, I know these are the notes of which of the two? Miss Hughes. But it could be said that's her take on what's going on.
That's her take on it.
But the assessment is the assessment of both social workers together. So they've discussed it and come to a joint view, which is slightly different from the view that's recorded in her notes.
But her view is that from an appropriate adult point of view, because we're talking about what an appropriate adult could do if in the course of the assessment there's an observation that someone's become emotional.
Yeah.
You'll recall in the ADCS guidance says, well, maybe they could intervene to say, can we take a break, or check with the young person, are you okay? Is everything okay? Are you finding it okay? That's a very simple, logical.
But I mean, the social workers noted that he was distressed, and the joint view appears to be that was when he was talking about his mother, and they noticed it, and one assumes they didn't plough on with their questions until he'd composed himself.
Well, we don't know. We simply don't know.
Oh, okay.
We don't know.
All right.
We can't extrapolate from that.
All right. So an appropriate adult would have kept them on side in a way that they might not have kept on side themselves.
Presumably, these interviews are not recorded.
No, they're not.
Let alone videoed.
No, they're not recorded, and I think there is not over judicializing things and expecting a verbatim note, and I don't suggest at all that they need to.
Well, that's of course the problem. Once you do have a verbatim note or whatever, you open the road to any amount of litigation.
Yes, but
on the other hand, yes,
the reality is the judge is faced with making decisions on the basis of the evidence that was adduced before him, and that's what he did. Is essentially my point is what he did is he looked at the evidence before him, he saw that, and he goes, well, it's something that actually, when you look at what the role of the appropriate adult is as described, that is the kind of thing that an appropriate adult could do. Thing and say, hang on a minute, let's just wait. Another point is, so the neuro passport issue, you can find that at page 93 of Ms. Hughes's Hughes's notes, for example. At the top of page 93, it says passport in Sudan, but illegal name, even Malta and Italy. The notes aren't very clear, but illegal name, and then lower down passport in Nier. So the issue that I had identified earlier, in Nier, the language, in the name of someone called Nier, all we have at the moment is these notes. And these are the notes that were the basis of the decision making.
Sure, but the decision doesn't refer to this question. So maybe when the two social workers put their heads together and wrote the report, Miss Hughes said, "What about this?" And Mr. McCrossan said, "Well, I just don't think this is a good point." So they didn't rely on it.
Possibly, but we're not talking about at the end of the assessment. We're talking about the appropriate adult. If this is a point that is being raised, then the appropriate adult can say.
But it wasn't made in the. That's my point. It wasn't made in the. It wasn't relied on the assessment.
Well, we simply don't know what the discussion was with.
Well, no, we don't. We don't. But we have to rely on the assessment as the primary evidence of what the social workers decided.
But you have my point on the emotional, and you have my point on the
Yeah.
Egypt.
Yeah,
So those are two probably better points that I will not press this one.
Okay.
And so neither of those points in relation to the issue of Egypt or the issue in relation to stress have to do with coaching. So he and
No,
the judge's analysis
yeah.
is not that he was coaching.
No.
The appropriate adult would be coaching, but the appropriate adult could say, hang on a minute, let's just clarify this.
Yeah. Okay. It's either clarify or hang on a minute. Let's slow down.
Yes,
Yeah. Okay.
So we say he stayed entirely in his lane in terms of his analysis of what an appropriate adult could interfere with, what the appropriate adult couldn't interfere with, and asked himself the question is this material to the issue of fairness? And you can see that at paragraph 38, he again doesn't say, well, this alone would have determined it, because he had already considered the interpreter issue, and he acknowledged Lady Justice Andrews' decision in AK that it wouldn't render all assessment interviews unfair. So as a matter of in terms of principles that are being said, and whether or not it's possible for this judgment to be read as laying down any other principles, he's very explicit and expressive about it not being a principle. And he's very explicit in that paragraph that on the facts basically, my respectful submission is it can't get clearer than on the facts of this case, the combination of the lack of an appropriate adult and interpreter combined to render the interview process one that was unfair. So he made a decision very clearly there, and we don't think that you can read that in any other way to set down any principle.
Yeah, but he is clearly saying, on the facts of this case,
Yes.
the combination of no appropriate adult and no interpreter were enough.
Yeah.
Yeah.
But
Okay.
he's not saying in every other case.
No, I understand that.
And then there's a question of minded to,
Yeah.
which isn't a part of the. There's no direct head-on challenge to the analysis of his analysis of minded to. It doesn't form a separate ground like appropriate adult and interpreter. But given my learned friend's position is that it feeds into the general analysis of fairness, one just needs to have a look at that. I mean, the starting point is the appellant doesn't dispute that the things that the judge said weren't put to the individual. And I get that a passport thing didn't form a part of the decision, but the other 2 points about the trip to Egypt and the Malta issue were part and parcel of they were actually the 2 reasons for finding dishonesty. And
Sorry, so you're saying those 2 weren't put to him as in anything that could be described as a minded to process?
Well, there is nothing before the judge that says that, other than the witness statement saying we did. The witness statement says we did, but the judge says that the notes say something different.
Yes.
And what he describes in that point is in his factual finding at paragraph 11, that the actual document itself is illegal. So we went go back to the document at paragraph 11.
Sorry, were you suggesting that the social worker's witness statement said something different?
Yes.
And was that an issue the judge dealt with?
I don't believe so. But as your ladyship says, well, if we go by what the assessment itself says, it's quite clear what the assessment says, and there's not a dispute as to that being an inaccurate summary because you can see for yourself what the assessment said.
Right, so you can look at extraneous material for some purposes, but not for others.
Well, I've only looked at the notes, and also the submission that, well,
it's a point of principle here. I mean, either the primary material, the only material you can look at is the social work assessment, or you can look at everything else.
But even that, my lady, it's possible to look at the assessment itself and say, well, under all available sources of information, the 2 social workers took all of that into account. And it's also possible to say under section 5 of the age assessment decision under age, the first issue that the social workers deal with is dishonesty.
Sorry, I'm probably being really slow. The assessment just says the social workers explained the reasons for their thinking and reasons which form the basis for the assessment. It doesn't say they didn't put to him the factual.
The notes also make it clear. So the notes were part and parcel of this as well. The age assessment says, in this meeting, they say, we didn't think it was possible that they could consider him to be a child. They explain the reasons for their thinking at this time, the reasons which formed the basis of this assessment. They explained the reasons. They didn't say, well, what do you have to say about this before we come to a conclusion? That's the important point about minded to, is that you provide them with a provisional view, you tell them what the concerns are, what do you have to say about them,
Okay.
do you then say...
I misunderstood you.
Yes.
So your point is, as I understand it, neither the decision nor the social workers' statements nor the notes say that the social workers put these 2 points to him.
Yes.
Right. Okay. Well, let me just write that down. All right.
And just for your note as well, that's at page 117 of the supplementary bundle is Mr. McCrozen's note, which has a whole heading that says outcome and what they did. And that's his contemporaneous note of the assessment.
Right.
And essentially, they what he says, I will just ask you to pick that up. What he says they did, is that he was told about his physical appearance, and then told that they can't accept him to be a child or take him into care.
Sorry, which page or paragraph was that?
Very last page.
Right at the end.
Right, I know it's right at the end. I just want to get the right reference.
117, heading outcome.
Thank you.
So sorry, is this the?
Supplementary.
Yeah.
This is
What I'm just checking. This is a transcription of his handwritten notes, is it?
This is an exhibit that the appellant has adduced, so I'm assuming this is a transcript. I don't know that it's a transcript. It probably is Mr. McCrozen summarising this.
Well, I'm assuming it's a transcription of his handwritten notes.
Yes.
Yes,
Is that what?
It says my typed notes from the age assessment are exhibited. He says that in para 9
Yeah.
on page
Okay.
113.
So that's a transcription of his notes. Okay.
Grateful.
Well, not even that. No, these are his typed notes.
His typed notes.
Yes.
Thank you. I hadn't read it carefully enough. All right.
So that's his record of what they did, and you can't find in that any questions asked of the kind that is identified by the court in paragraph 39, which were the two key. So we'll put aside the past, but the two other key points that were recorded in the age assessment as the basis for dishonesty. And so the judge then doesn't say, well, this is it, this thing is enough. He says at the end of that paragraph 39, if there had been an interpreter and there had been an appropriate adult, then the failure to allow the chance to explain away may not have been sufficient on its own. But when you look at it cumulatively with those absences, they amount to unfairness. And just to sweep up a couple of points before I deal with the remedy point, one passage of Ham that I hadn't taken the court to is a passage at paragraph 6 of Ham. And if I could ask my ladies and my lord to turn that up.
I'm so sorry. Can you just remind me which tab it is?
Yeah, it's tab 11.
Thank you.
So it begins at paragraph 5. It's headed, it's just 55 is just a description. Paragraph 6, he says there is a distinct requirement that age.
Sorry, I think we're still getting there. Only I am. Right, look, 4th. Is that it?
It should be Pam, page 199, paragraph 5 is the heading. B, fairness and decision in Merton. It's at the bottom of page internal 1783 of the judgment report.
Yeah.
Sorry,
I'm being slow again. I think I must have misheard the paragraph reference. My fault.
5 and 6.
5 and 6. Thank you. 7 skips behind. Yes, sorry, my fault.
So 5 is just a descriptive paragraph. For 6, so 5 talks about the jurisdictional fact finding, and then 6, Mrs. Justice Swift says there's also a distinct requirement that age assessments must be the product of a fair procedure. And you can read on, and it says at the end of that paragraph, if the decision has been taken by a process considered not to meet the legal standard of fairness, it can be challenged and may be quashed on that ground alone. and this is in the context of him considering both the fact-finding jurisdiction and the procedural jurisdiction.
But it's a slightly odd conclusion, isn't it? Because normally, on a judicial review, the court isn't in a terribly good position to tell whether or not the breach of fairness would have made any difference to the decision, the substantive decision. Although in some cases it will nevertheless. In a very clear case, the judicial review court will say, this was unfair, but it was inevitable that the same decision would have been reached. What seems peculiar is in a case where the judicial review court can decide the substantive merits, it's nevertheless quashing on fairness grounds alone, because it wouldn't be in a position to tell whether or not the breach of fairness made any difference without also deciding the substantive merits. I'm not asking a very clear question, but you see what I'm getting at?
I think I get where you're getting at, but what's notable with Mr. Justice Swift's analysis in Ham itself is he does make findings of procedural unfairness in a particular assessment. So he doesn't find for the claimant on the appropriate adult argument.
Yeah.
He does pick up on the issues of minded to and the relevance of that to the conclusion, and you can find that in your. I don't necessarily.
Well, I think we've already looked at that, but
I just want to give you a note of.
Yes. Okay.
47 to 50 of the 51 of the judgment.
Sorry.
47
to 51 of the judgment. Yeah.
Because internal page 1799B to 180C.
Yeah.
So he makes a finding relating to the issues of relevance, and he identifies the points that they should have put to him at paragraph 50. So there were 3 particular points that they should have put to him, and you can see.
Well, he's recording a submission.
Yes, he was recording a submission, but if you go over the page at 51, he said, "I am satisfied as, from the points put to him, the latter points, which were thought to go to his credibility, feed into the conclusion that his apparent age was not his real age." For that reason, those points, so the points that were recorded in 50, should, in fairness, have been put to the claimant.
Got that. Yeah.
And then, in terms of the way he dealt with the relief and why there was a declaration instead of a quashing, you can see if you read that, it makes sense what he says at 55, at paragraph 55, at between B and C. In this case, several matters combine to support the conclusion that a declaration is sufficient recognition. The error that I have identified, so he only identifies those 3 matters, yet rendering the decision process unfair is not an error of the most serious nature. So for him, that one point, as opposed to all the other points that were put before the court in that case, that was one fairness point. So there were other points about interpreter and appropriate adult, which in that case he said no, that's not unfair on the facts. But this point he said it was unfair.
Can I just ask you this? Is there a word missing from 1, 2, 3, 4, 5, 6, 7, 8, 9, 10? It's about 10 lines down. He records an agreement between the parties that the part of the challenge concerning the council's substantive decision was correct. Should it be whether?
Yes, I think so.
Yeah, because I was having trouble.
Concerning whether the decision. Yes,
Yeah.
So it's missing a whether.
Yeah. So the editor of the PTSRs, they're normally very good. Didn't pick that up. All right, that's helpful because I was having trouble understanding that sentence. Thank you very much.
So in this case, you can see that it was a combination. If we go back to the judgment, in this case, as opposed to Ham, the judge looked at the circumstances of this case. We said the because he's made it very clear that he was only looking at the facts of this case. He was driven to the conclusion, and again he repeats that at paragraph 40. So you can see in conclusion and drawing together the various short failings relied on by the claimant in his case, I am driven to the conclusion that the combination of a lack of an interpreter, the absence of even the offer of an appropriate adult, and the flaws amounted to a clearly unfair process.
Yeah.
And we say just as the same that we have said, which is it is a fact-sensitive conclusion that was made by the judge. And he was, I hope to have shown you that he was very careful in being expressly.
No, I absolutely understand your submission about the terms of the judgment. That's very clear.
And so it is not possible, although, yes, Mr. Justice Swift extracts from it points of principle. Those are not points of principle that are in dispute or require clarification.
Yeah.
And those are principles that have run through the thread of Merton and other cases about fairness being dependent on the circumstances. As a matter of public law, as a principle, fairness, there's no single standard in any event. So it doesn't disturb the sort of general public law principle that fairness depends on the context. Because context, as in any public law case, is relevant to the outcome.
Yeah.
I'm very mindful of time, so I just wanted to so it's our case for the academic point. I'm going to come back on the remedy thing, but on the substantive issues that are relied on to say that there's a general point of public interest that needs determination.
You just say the judgment's very clearly confined to its own facts. Okay.
And then on the remedy point, we looked at paragraph 40 of the judgment, which is the reason why a quashing was made in that case, in this case, was because the court looked at the combination of everything, making the process a clearly unfair process. And the grant or otherwise of discretion in a given case is one for the judge to exercise. It's not really, I don't understand that it's suggested that he was irrational in coming to a conclusion that because the process itself was clearly unfair, it wasn't a reasonable conclusion for him to have drawn to.
Can I just explore one point with you, please? The assumption that Mrs. Justice Thornton seems to have made in the Kent case was that if the assessment were quashed, it would mean that no one could refer to it ever again. And I'm slightly oversimplifying. Would you agree that that is a consequence of the quashing of the assessment? Because as I understood Miss Rowland's concern was, this is a historical document and it should be available for future reference, subject to the proviso if the appeal is dismissed for whatever reason that the decision has been quashed.
I think it depends on the case. Is what I would say. Because I was going to take you to two cases where similar outcomes were given and the reasons were clearer.
Right.
Because I think as a general public, I did look at this as a general public law principle that, what's the point of quashing if it doesn't make a difference? And I think there has been a general principle under Boddington, which is if it's unlawful, then it's a nullity. And that principle probably is the principle that runs throughout why judges have in age assessment cases that are purely about judicial review come to a conclusion either to quash it. And the distinction between those cases where a quashing order or setting aside is made, such as Merton and N.A. Croydon, is that those cases didn't then go on to deal with fact-finding. And perhaps the best one to look at is N.A., which is at tab 3 of the authorities bundle. And the findings that the judge makes obviously turn on the facts of that case, but the findings you'll find run from paragraph 50 to 60. And that's internal page 56. That's page 56. The tiny page numbers at the top. And so his conclusion on the assessment and the challenge is paragraph 60. That's his conclusion that it was a wholly unfair process that he was going to quash.
Is this a pre or post Aon Croydon decision?
This is a pre-Aon Croydon.
Pre-Aon Croydon.
So there wasn't a request, so to speak, or consideration of a fact-finding.
Yeah.
But we say here...
So nobody knew that you could send it off for a fact-finding exercise?
But it's not a mandatory. I mean, I would also just say that it's desirable for the process to be dealt with in that way, but in a lot of cases, one of the reasons why the judges transfer the case is because one of the remedies that has been sought is a declaration of the person's age.
Right.
Because in order to have a declaration, the court has to invoke that fact-finding jurisdiction.
Yeah.
If you don't invoke the fact-finding jurisdiction, then how can the judge do anything beyond that?
Yeah.
And in this case, a declaration wasn't sought in relation to his age, and that's just a point of relevance. In AB and in Ham, one of the remedies, ultimate remedies in the pleadings was a declaration. So it's quite understandable that in those cases, the parties on succeeding on the procedural argument also wanted just to knock it on the head and have a fact-finding.
Yeah. Okay.
So that's a relevant context as well. But as we are on, I hope we're still on NA, if I could just ask the court to look at 69 and 70. So in 69, Mr. Justice Blake says, for halfway through paragraph 69, says, for the reasons I've given in my judgment, the June assessment was seriously flawed and cannot stand and must be quashed for the avoidance of doubt. So there was a previous assessment as well. I quashed it in December because it was never formally rescinded. And in my judgment, the defendant may have continued to be influenced by factors in the same decision and consideration factors. So this is a case where they had an original December assessment and then did in mid-proceedings did a June assessment. And so the principle extracted from there is, well, if you're going to do assessments afresh because it was tainted by serious unfairness, then you should do it with a fresh mind.
Yes, but it's a slightly different point. The issue, I don't think Ms. Rowlands was suggesting you could rely on, well, maybe she was, but what about the point that she appears to be concerned about, which is that it is a record of what happened at a very early stage in the process. So it's a record of what he said and so on and so forth. And her concern appears to be that if the decision is quashed, then no one can ever refer to it again. And what I'm asking you to address is whether that analysis of the effect of quashing is correct.
I don't think you can say that you can never refer to it again, but
right.
you obviously have to be very, very careful
right.
what you do with the information, because if it's quashed for a reason.
Yes.
And it's quashed because it's unfair and the information potentially is unreliable. But in any event, in this case, there was a fairly detailed judgment on the factual matters that were part and parcel of the problem. And why Kensington and Chelsea insisted that they weren't going to accept his age.
Yes.
So I don't think you can go as far as saying, well, they can't then therefore even look at the judgment. I mean, it's a public document and a record of the party's position as well.
No one's saying you can't look at the judgment. As I understand it, her concern is if the age assessment remains quashed, it can't even be consulted as a historical record. And the first question is that right or is it wrong?
Well, as a matter of general public law principle, it would be right that it's a nullity.
Right. Okay. That's all. All I want to extract from you is your position on that argument.
It would be a nullity because it's a quashing order.
Okay.
And I think that is supported by the very long line of cases
Yeah, so I mean that was the premise of Mrs. Justice Thornton's approach in paragraph 58 of her judgment. I'm just asking you whether you think that's right or not, and you appear to be saying yes, that is right.
That is right.
All right, that's very helpful.
And we say if the criticism was he shouldn't do it because he prevented anybody else from looking at it. Well, it was within he exercised his discretion in that case on the basis of his fact finding, his findings of law and errors. That it was not.
Sorry, there are two separate points. One is the effect of the quashing order, and the second is whether or not we should interfere with it. Those are distinct points.
So the effect of the quashing order, I think I've addressed.
Yes.
And whether or not it was rational, it was irrational for him to do it. We say no because of the findings that were very.
Well, you say he didn't err in principle, so it should stand.
Yes.
All right.
And in an event, in this case, the complaint is well, then therefore Southampton couldn't have possibly known anything about it, which itself is also factually not the case, because Southampton had the assessment well before, at the pre-action stage, before this case was even issued, and was actually provided with a copy of the judgment. So if there is a concern from the court that there must be clarification on this, this is not the case to arrive. It goes to the academic point again, is that this is not the case on which this could arise. It's a very unique set of facts where you happen to have two local authorities who are both tasked at different stages of the respondent's life in carrying out age assessments. But it just so happens because of the procedure of this case and the facts of this case, they both knew what was going on and they knew what the disputes were because they were given the documents and they had the benefit of insight. And we don't know what they did with that, but that is within their discretion. You can't say, well, we need to respect Kensington Chelsea's social workers' discretion and social work judgment, and not Southampton's judgment call in terms of how they conduct their age assessment, which isn't before the court, which isn't before the court alone.
I don't think there's any suggestion to that effect.
And so even insofar as the court has concerns about the issue, that's not something that is a theoretical issue in this case. It's not something that arises from the facts and circumstances of this case because uniquely and unusually, the people who needed to see it have all seen it.
Can you just remind me the date of the age assessment by Southampton?
That is in the. Sorry, I might give you the best reference. It's in the agreed note at tab 1 of.
Oh, well, if it's in the agreed note, I'll just look at that. So that's the first document in the supplementary bundle. Thank you.
Paragraph 9 of the note.
Thank you.
So we say, in that sense, either you look at it through the lens of academic but general point of importance, or as an issue of substance and merit, and ground 5 should be dismissed.
Okay.
Can I just turn my back?
Of course, yes.
Unless I can assist you further.
Do you have any further questions? No? No, thank you very much indeed. Yes, Miss Rowlands.
My lady, on that last point first, I'm grateful to my learned friend for the concession that the assessment carried out by Kensington and Chelsea should not be obliterated from the record, because that was the position adopted by the claimant before the court below.
I'm not sure that was. I'm not sure that was her position.
Email is I asked for. One thing we would like to add to the order for clarity is that RBKC should be permitted to disclose the documents in the case to any local authority who may be carrying out any subsequent assessment of your client's age. Do you have any objections to that? And the answer to that was yes. The assessment is being quashed because it was undertaken by an unfair process. It should not be relied upon by subsequent local authorities. So it was very clear to me that it was being objected to.
But as I understood Miss Lou's submission, she was saying that it is a nullity. Yeah, so you're sticking to the positioning that you advanced in correspondence. Yeah, yeah. So I don't think she's conceded anything.
I thought that she was saying it was still part of the record. In answer to your
well, I mean, we had quite a long exchange about that, but my understanding of her eventual position was it's a nullity and it's as if it never happened.
In my submission, that would be the wrong position to adopt for the reasons I've already given.
Yes.
And also because the guidance makes it clear that it is part of the record, that records must be kept. In dealing with children, you have records of practically everything that they do at every step of the day. This would be something that could guide other local authorities in making decisions that are fair to both sides in other cases.
All right.
And in my submission, the fact that Southampton have reached the contrary decision to that reached by Kensington Chelsea demonstrates the risks inherent in the position that they adopt, which is that the decisions are made without having regard to all relevant facts. The relevant facts in this case including the fact that there had been previous assessment in which the claimant had given different versions of events, and in which he had had the opportunity of being able to put a witness statement together with the assistance of solicitors. And my lady, let me just give you two references that I wasn't able to give you in the course of my submissions this morning. The first of those is to the Home Office documents. I said I didn't think they were in the bundle, but I was wrong on that. They're in the supplementary bundle.
Yeah.
At page 102.
Thank you.
107. I can't read my own
107.
handwriting.
All
There
right.
you've got the record that the Home Office.
Would you like us to look at it?
Please, yes. Have recorded that he claimed that his date of birth was 25/5/2004, but they've ticked the box marked your physical appearance and demeanour very strongly suggests that you are 25 years of age or over. This form puts into practice the policy which for the Secretary of State, as I indicated in my very opening, is intended to make safeguard against detaining anyone who is a child or even might be a child.
We've understood that.
You will see further on that the at page 109 their records show that he entered the UK on 28/5/2001 and was age disputed by CIO KIU. KIU is the reference to the Kent Intake Unit and deemed to be over 25, so was never age assessed by any Kent Intake Unit social worker.
Right.
Because Kent bear the brunt of the arrivals at Dover and were in a position at about this time of not having room for any more children.
He was moved on to your law.
No, it's not that. Kent Intake Unit had got social workers who were doing age assessments to basically supplement Kent. Their age assessment procedures were subject to the decision in MA in Coventry that you will have seen references to, first of all in HAM, and also it came out between the hearing of this case and judgment being handed down. So my learned friend and I made further submissions on the impact of that case. But the reason I want to just look at this is because I do want to make it clear that there is a different approach by the Secretary of State as opposed to local authorities. So when you look at cases like ZS, which was a case against the Secretary of State, caution needs to be adopted in looking at that. The other reference I was unable to give you this morning was to where I made reference to the fact that when he was asked his date of birth, SB had to check on his phone, and that is at the bottom of page 90 in the notes of Miss Hughes.
So that wasn't relied on in the assessments. I'm not really sure why we're being.
Well, the point
shown
that I made this morning would it have been helpful for Southampton to know that before they reach their conclusions to how credible his version of how he knows his.
But I don't
date
see
of birth
how, if it wasn't relied on by your own experienced social workers when they made their formal decision.
Well, that is absolutely right.
I mean, isn't this just a really small...
I just wanted to give you the reference to where
okay.
it was recorded.
Okay.
But the key point, my lady, is indeed what the social workers relied upon.
Yeah.
And my learned friend's submissions, I would argue, show the danger of looking at subsequent events to try and decide what people should have done at the time. My lady referred to the case of Ermakov, and it is, of course, the decision itself that stands. And the question is, what was going through the mind of the social workers carrying out this assessment at the time? And in light of what they knew at that time and what they were observing, what did fairness require them to do? And was their decision on that one that was within the range of decisions that was open to a reasonable social worker in regard to what was known at that time? And the social workers, it's been submitted by my learned friend that they were wrong to rely on points that undermined his credibility. But if we look at the age assessment itself, it does not rely on credibility points at all. The conclusion points in the middle of the age assessment pages, I'm afraid now. So
259.
And I remember Lady Laing has got it separately.
That's
so
all right,
I'm
I've got
going
it
to go
separately.
to, so it's page 258 within the bundle, and it's page 4 of the sorry, it's not that one. It's page 260 of the assessment, page 6 within the assessment. Summary and analysis of reasons, and you've got paragraphs about SB's physical appearance, about the benefit of the doubt, about his demeanour, about his confidence in communication, and he's got at the bottom the conclusion: the assessors primarily rely on their observations of his physical appearance to make a determination of his age. There's no reference to, and because he lied about this, that or the other, we find he's not credible, and that's part of our reasoning. And of course, Ermakov is a decision from the homelessness sphere. And I was reminded of the words of Lord Newberger in another homelessness case, Holmes Morehouse, where he reminded us that a decision can often survive despite the existence of an error in the reasoning advanced to support it. For example, sometimes the error is irrelevant to the outcome, sometimes it's too trivial, objectively or in the eyes of the decision maker to affect the outcome. Sometimes it's obvious from the rest of the reasoning, read as a whole, that the decision would be made the same, notwithstanding the error. Sometimes there's more than one reason for the conclusion, and the error only undermines one of the reasons. Sometimes the decision is the only one that could rationally be reached.
That's not in the bundle. Could you just give us the neutral citation and
that's
the
Holmes
paragraph,
Morehouse
please?
and Richmond, and it's 2009 UKHL 7.
Yep.
It is, of course, a typically Newbergian.
Yes, sorry, which paragraph of the judgment,
That was
please?
paragraph 51 I was reading.
51, thank you.
Earlier in that judgment, he'd pointed out that decisions of homelessness reviewing officers are not written by lawyers, and they're not to be read as statutes.
Yes, well, I think we're all familiar with those.
A benevolent or nitpicking approach. A benevolent, not nitpicking approach should be adopted, and I would urge the same on the court.
Yeah.
Looking at events through the mindset of what the social workers had at that time, that was their thinking. And so, even if there was anything about the credibility points that undermined their approach to that, the decision is squarely based on something that isn't affected by the credibility points.
Yeah.
The Mind at Two process has been referred to. The social workers went through what they were minded to hold against him as and when they did it. That was the effect of their witness statements. And of course, you see that recorded in particular in relation to his appearance and demeanour. And you see that at page 258, the fourth page of the
assessment.
The assessment itself.
Yeah.
And is more than that needed in these circumstances? It is, in my submission, a decision that the social workers were entitled to reach, that no further mandatory process was required when they were so satisfied of SB's aid on the basis of his appearance and demeanour. So, coming back to the question of whether this is academic, and the question of remedy, if this appeal succeeds and the decision is unquashed, then there is a decision that Kensington and Chelsea can rely on. If SB were to return later on and say, please exercise your discretion in my favour, I was alluding to the case of GE Eritrea. My learned friend is quite right, and I was making my submissions on that this morning. It would be something that he would be entitled to ask Kensington and Chelsea to do, to exercise their discretion in his favour in these circumstances. And of course, if Kensington and Chelsea refuse to exercise their discretion in his favour, to challenge that by way of a further judicial review. So we could have further judicial review arising out of
and just help me with this. He would be entitled to ask for those services until the age of 25. Is that right?
Yes.
So, on the basis of the age as assessed by Southampton, when would he reach the age of 25? Does anybody know the answer to that?
2029.
2029. So up until 2029, there's a potential liability to be asked to exercise this discretion on your case. All right. Miss Lim, I might let you come back on this point, Miss Lee, if you're troubled by it.
He might not be saying at the moment he wants to do it.
No.
As I pointed out earlier.
Yeah, so you're saying there's a potential liability, however remote it may be, that you could be, you're potentially liable to be asked to exercise that discretion up until 2029.
Yes.
Right. Okay.
It's also application for social housing on the basis of being a priority need because of being a former care leaver to Kensington Chelsea. They might be able to, might be asked to do that, and that would be ad infinitum until he dies, really.
Oh, I see. So you're entitled to priority need if you're a former.
If you're vulnerable as a result of having been in care.
Right.
Sorry, could you say that a bit more slowly? You're
vulnerable in priority need. You'd be vulnerable as a result of being in care. So it's not just having been in care, but being vulnerable as a result of having been in care.
But whether or not this assessment is quashed, he would still have been in care.
But not to Kensington and Chelsea.
No, but surely it's the factual question is whether he's a care leaver at all, not which local authority's care he was under, is it?
But
Miss Lee's nodding.
Southampton's decision was taken on his 18th birthday, so he was never accepted as a child in need during the age of his minority on anybody's case.
Well, so it doesn't matter, does it?
Prior to the finalisation of the assessment after the judgment, he was taken into care whilst he was still a child by Southampton.
Right.
He was pending assessments.
And how long was he in care for?
So it was, the judgment was February 2022.
Yeah.
The final assessment was sometime in May 2022. So there were, on my calculations, 13 weeks. So it's March 1st. So it's paragraph 8 of the agreed facts and circumstances. 1st of March 2022. Southampton started accommodating, and 5th of May 2022 they accepted his age.
Right.
I mean, I could address you on all the Children Act duties, but there are various ways in which you can be a care leaver. You can be a former relevant child, you can be a qualifying child, and qualifying child have various powers. And I could produce a note on that, but I don't feel comfortable trying to.
No.
interject
I
with my-
understand that. I mean, I think I know it's a ball we'll have to do further. I think it would be very helpful if we could just have an agreed note after the hearing, just explaining in a very short form with very short references to the relevant provisions the extent to which, on the agreed facts, he might be owed any duties by.
Yeah, I'm happy to cooperate with that.
Yes.
It's just that our position is you just can't.
No, okay. Well, I understand that, and if there's a disagreement, then we'll know the extent of the disagreement. But I think it's unfair to ask either of you to deal with it on your feet
I'm grateful.
at this time.
I'm grateful for that.
All right, thank you very much. Yeah, noting the time, Miss Rowlands.
Yes,
You,
I've not got much more, but
It's
I
your
think
peroration.
further on the academic point,
yeah,
what I would say, it's possible for a case to be academic for one side and not for the other. And I think this may be one of those cases. SB may not be concerned about the way this case goes as he sits there right now. Those instructing me are very concerned because it's not academic for them to know how they are to conduct age assessments in future.
No, it's academic as between the parties because there's no dispute for the court to resolve as between the parties. You're saying it's of wider interest to you because you say other similar cases may come along and you want to know what to do.
Indeed, and are coming along.
So that's a
on a
point that
regular
goes to the
basis.
exercise of discretion to hear an academic appeal.
And just before permission to appeal was granted, this issue was ventilated by the court. So the solicitors then acting for SB wrote to those instructing me, copying the court in, to inform the council that Southampton had found the respondent to be his claimed age and would be providing him with age-appropriate support. And they said they cannot see how it is necessary to continue with the appeal. We asked for copies of the age assessment. They were not forthcoming. On the 26th of May, the Civil Appeals Office emailed those instructing me to ask if we wished to continue. And once we had sight of the age assessment from Southampton and considered our position, we then confirmed that to the court, and the judgment giving permission came after that. So the court was aware of the issue of academicness or not before granting permission to appeal. And it would be my submission that in the circumstances of this case, this is one that the court should consider in its fullness.
Okay. Are those documents in the supplementary bundle?
They're not. I can provide them.
Would you please?
Where your ladyship would wish me to.
Yes, please.
But it's in our agreed note if that's helpful.
Oh, it's in your
That's
agreed.
one of the ways in which we've tried to shortcut the amount of.
Okay, so it's in the agreed note.
10 to 12 of the agreed note.
Right, let's have a look. Right. And when was it? Just remind me when the permission decision was?
It was August the 3rd, 2022.
Right. No. As my lady's pointing out to me, I mean, we don't know whether or not the judge saw this correspondence when she granted PTA.
It doesn't leap off the page that she did.
No.
But the respondent's notice also made the position clear.
Okay. All right. All right.
I was going to say something about the remedy that was given in other cases. In AB in Kent, what happened was this. The procedural grounds were lodged, as well as the ground saying, I've got a positive case, I am only whatever age it was, I can't remember, for this reason.
Yeah.
And I conceded that permission should be granted on the procedural ones.
Right.
My learned friend Mr. Rule argued that I had thereby also conceded that it should all go to the tribunal. And so we had this bizarre case whereby we were arguing about the validity of an age assessment, where permission, as Mrs. Justice Thornton found, had also been given to go to the age assessment, to go to the tribunal to have an age assessment.
Does this really
Which I just
matter?
thought was
Because she
not-
decided that it should go off to an age assessment anyway.
Yes, and also ordered my clients to do a further age assessment, which permission to seek judicial review of that decision being granted before the decision had even been made. I was not happy, I can tell you, with that decision.
Did
However,
you appeal?
at the end of the day, this reduces age assessments to the status of just evidence in a fact-finding exercise,
Yeah.
whereas they're not. They're the decision which is the subject of judicial review.
Right.
Mr. Rule took the same position before Mr. Justice Swift in HAM, and he met with a rather more robust response on that one,
Okay.
and that is clear from
Well, I think we've been taken to the relevant passages in the judgment.
yes, it's,
Yeah.
it's right at the end of the judgment. What Mr. Rule's position was is that you need a fair Merton compliant assessment to be part of the evidence in a fact-finding hearing.
Yes.
But if there is a fair Merton compliant assessment, my lady, in my submission, that should be the end of the case. That should be all that the court needs. And in my submission, in this case, that was all the court had, and should have stopped at that point. Let me just turn my back for 2 seconds. My lady, is there anything else I can assist?
Oh, just one point. At lunchtime, we were promised a copy of your skeleton argument in its latest incarnation, and I haven't yet seen that.
You do have the full bundle that was lodged yesterday, and it's in there.
Sorry, and where is that?
I was told it was on your desk now. It did.
I now have it.
Oh, I see.
I've got a
Yes,
Full
copy.
bundle. Oh, I see. In green. Sorry, I put it there.
I
Yeah.
apologise for killing too many trees, but hopefully there.
No, I'm
updated
dismayed
version.
at the number of trees that have died
Yes.
in the pursuit of this appeal. But anyway, good. So
No,
anything
sorry,
else?
nothing else. No, thank you very
No?
much.
Right. Well, thank you to both counsel who've been doing the talking, and thank you also to Ms. Lewis Jr., because I expect she's done a lot of hard work too. And can I also thank everyone sitting behind counsel, because I know in cases like this you've all worked really hard as well, so we're really grateful for all the preparation that you've done to help us with this hearing. I doubt if it'll shock you to hear that we're going to reserve our judgments, and they'll be handed down in the normal way, which these days is remotely. We would welcome small corrections of small errors such as typos, but we don't want a repetition of what happened in front of the judge, if that's possible, please. And we also like you to agree in order if you can. If you can't, please may we have written submissions about the points of disagreement. Can I please draw your attention to the embargo that will go out with the draft judgments? You probably know, because of the Counsel General for Wales case, that there's been a recent decision of this court emphasising the importance of compliance with the embargo, and despite that, we still get cases where people don't comply. So it's really, really important that you observe the terms of the embargo, and that clients are expressly advised on the terms of the embargo, so that they don't go off and tell somebody else. Because I've actually had a case where that's happened. All right. Thank you all very much. Anything else? No? Just checking.
Could
Yes.
I just have an indication in terms of the agreed note? When would
Yes.
you like that?
Well, I don't want to be unreasonable. I'm sure you've all got other commitments. I mean, would 7 days be unreasonable?
That would be fine.
Yes, and can I just clarify exactly what the note is to cover?
Yes. Well, you're making a point about the potential liability of your client if this assessment's quashed.
Yes.
And it may be a question that doesn't arise because we may decide the whole appeal's academic and we decline to deal with it. But if that question does arise, we would like to know precisely why you say it matters and with references to the relevant statutory provisions. And if you can agree and note so much the better. If you can't agree, then just please indicate which bits aren't agreed. Is that clear? Yeah? All right. Thank you very much. And I'm sorry this is overrun. It's entirely my fault because I've asked a series of ignorant questions, but your answers, believe me, have been extremely helpful. So thank you very much.
Court rise.
Looks like my hearing tomorrow has been cancelled, so that's nice. It gives me a bit of time to